So this is our first guest speaker coming to Cardozo as part of the Intellectual Property Law Society's semester program. William Patry is the Senior Copyright Counsel for Google and deals with many of their Google matters that Google deals with. I'm not sure if he'll be talking about that. He's also testified or worked with the U.S. House of Representatives and is also the author of a 8-volume treatise on copyrights and a separate treatise on the fair use doctrine. So making him, I think, one of or the most prolific author on copyright, I think.
I'm thinking it was written more. It doesn't mean it's good.
Okay, well, he's written the most. He's certainly written the most. So we're happy to have him here, and without further ado, please.
So Michael didn't mention, of course, that I was a faculty member here from 1995, the fall semester, until fall semester of 2000. And I think I've gone downhill since I used to dress in a suit and a tie and stuff like that. And now since I'm at Google, I have to dress like a Google person does. Otherwise you stand out. You know, it's that form of conformity too, right? There's lots of forms of conformity, including casual dress. When I taught here, and I used to teach in this room too, so it's changed a bit since I was here. Some of the places I used to hang out, in addition to the bootleg stores, which are on the other side of Washington Square, on Thompson Street, Sullivan Street, things like that, when you used to buy, CDs. But when I wanted to buy non-bootlegs, which was rare, you go to the Virgin Megastore, or there was an HMV, right? Or now, of course, you can't do that because they're not around, right? And the record companies would say that they're not around because it's your fault, right? Because you're just taking everything on peer-to-peer file networks. You don't want to pay for stuff, and they can't compete with free. I don't actually think that's the case. And iTunes showed, that people will pay. Tower Records, which I used to go to when I grew up in the San Francisco Bay Area, used to have a big store in Times Square, and they have a sort of different view about what happened. So there was this book that came out earlier this year called Appetite for Self-Destruction. And in that book, there's a quote from Russ Solomon, who was the founder of Tower Records. And he's talking about the pricing of CDs. I remember when CDs first came out in the very early 80s. I had one of the first so-called portable CD players. It was actually this big, huge thing like this, and you had to wear a strap on it. But I still thought it was pretty great to be able to go on to, I was living in Washington, D.C. at the time, to be able to go onto the subway system there and listen to music in a portable way on a compact disc. So at that time, the prices actually turned out to be lower than they were near the end of CD's arc. So Russ Solomon's talking about this, and he said, every holiday season, the prices would go up $1. So they were $14, and the next year 15, and then 16, 17, and 18. And the retailers tried to fight against this, and they said, this is his quote, damn it, no one's going to pay for that. You got to stop raising the prices. And he said the record companies would listen to them, but they'd laugh. It was like talking to a wall, he said. Now, not only were the prices continuing to go up, but of course the cost of production were going down. And the other thing that was going down as well were the royalties that were paid to artists. There was a guy, Mickey Schulhoff, who was a Sony executive, and he pointed out that while CDs really were an amazing thing for the record industry because people bought their albums over again, which is always a nice trick to get people to keep buying the same thing over and over again. And that's actually sort of a common business model for them. But the way in which the record industry really thrived also came at an expense to artists, right? And he says a not insignificant reason for the overall improvement of the record industry were the diminished royalties in terms of percents that were given to artists. So what were they? So on compact discs, the average that performing artists would get would be 9%. The labels received 46. The retailers like Tower, HMV got 45%. Now, with digital downloads, actually the amount that performers get has been reduced on average, right, to 8%. The amount that the labels get has gone up 22%, right? So they used to get 46%, now they get 68%. The digital service providers like iTunes and others get 15%, and credit card companies get 9%. Right? So you have a situation where the artists get 8%, but the credit card companies get 9%. That's sort of a strange situation there. This is from the Gowers report, which is a UK report on copyright. They have nice pie charts and data that they did on this. And they were a little surprised that credit card companies would get 1% more than the performing artists did. Now, that said, that performing artists have historically sort of gotten the short end of the stick from record companies doesn't really justify, copying stuff wholesale, not paying for it. And you read those sort of rationalizations, right? People will ask, well, why do you copy and not pay for it? And people will say, oh, well, the record companies are screwing the performing artists, so, I'm getting back at them. Not really a great moral position to take, right? The fact that, one other group is acting in an immoral way is not probably the best, moral compass to go by. Now, the damage awards in some of the infringement suits have been really rather shocking, and jury awards too, right? The Joel Tenenbaum case recently in Boston, the Jamie Thomas case in Minnesota had incredibly high statutory damage awards. One of them was was it 80,000 per CD, something like that. For something you could get for 99 cents on iTunes. But they didn't turn out to be sort of the best movement heroes. At the same time, the recording industry's campaign of suing thousands of people and sending cease and desist letters to hundreds of thousands of people is not the best approach either. It's certainly a disastrous business strategy, I think. And of all people, Edgar Bronfman Jr., the CEO of Warner Music, seems to agree. In 2007, he gave the speech in Macau, in which he said that the recording industry had gone to war with consumers by denying them what they wanted and what they could otherwise find, and as a result, consumers won. Now, what they won is not clear to me, right? Because in 2007, all the suits and the cease and desist letters were still going on, including the suits against Joel Tenenbaum and Jamie Thomas. So a fair question to me is, well, what should the record companies have done? Right? If it's not right for people to, copy stuff en masse, and it's not right for the record companies to go suing those people from doing it, what should have happened? And to me, at least, the answer is, especially being in-house, these are business things. Give consumers what they want. So there's a view that some companies have, media companies have, that content is king, right? Sumner Redstone says this. Rupert Murdoch apparently says it, every morning. Instead of Modia Nein Lafanecha, he'll say, that content is king. That's sort of his schma. But that aside, I don't think it's true. I think that consumers are king, right? Because without consumers, you can't sell anything. You may believe that your stuff is worth something, but it's in fact not, unless someone will buy it. You can say it's worth that to you intrinsically, and if you have your apartment for sale and you think it's worth a certain amount and no one wants to buy it, you can say, well, I'm not going to sell it. And so, okay, for you, it's worth that much, but you're not going to get money for it. Right? Same thing, I think, works generally for mass market stuff. There's an idea somehow that copyright is fairy dust, that somehow imbues things with economic value. And I say this because I was accused of having that view at one time myself, and I did. When I worked for the Copyright Office, I worked on our adherence to the Berne Convention. We joined in '88, effective '89, but there have been hearings going back to, I think, '86. And one of the issues was whether we had to protect the three-dimensional design of architectural works, the actual built structures, right? Famous, architectural works like the Chrysler Building, is a great work of architecture. There's a few others in New York like that. Not a lot. There's, the Frank Gehry, Barry Diller Building, and some others. We were supposed to have done that when we joined, but we didn't. Because we had to think about it. This is sort of the way sometimes the United States joins treaties. When you join a treaty, you have to sign on the dotted line and say, our law adheres to all the requirements of the convention. And it's a trust thing, right? Countries trust each other, of course. And so, when you sign, you say, yeah, we comply. But actually we didn't, and we knew we didn't. And some of the stuff we just said it's too hard, like retroactivity, which we did later in 17 U.S.C. 104A. So architecture was one of these things we decided we were going to do later. And so I was working at the Copyright Office, and I did a study for the Copyright Office on works of architecture, and I got really enthusiastic. I grew up in Marin County, California. Our Civic Center was a Frank Lloyd Wright building, and there were a few others. And so, I always liked architecture. And I bought tons of books and became a sort of fanatic on architecture. And so I really wanted to do this. And a friend of mine who worked there said, the problem with you, Patry, is that you think copyright's fairy dust, and that if you give it this copyright, then it's got all this amazing meaning. I, of course, denied it, but it was true. I did think that. And I don't anymore. It's not that I don't think copyright has value to people. It does. But giving copyright doesn't mean people are going to pay for it. You have to actually want the thing first. Then you'll buy it. And whether it's under copyright or not, we probably don't care about and shouldn't. I'll get back to this at the end, why we shouldn't care about copyright, or why copyright owners shouldn't want us to care about copyright. So I think it's a general economic matter, and I think it's true for copyright works too, that it's consumers who give things value, not copyright owners, by virtue of having copyright. So if you believe that that's the case, then the logical thing is to try to cater to what consumers want. If your deal is selling stuff, then you're going to want to pay attention to what it is people want to buy, and you're going to sell them what it is they want, not what you want to sell them, right? Because if you're just going to sell them what you want to sell them, you might not end up selling them a lot, right? So there's a great example of this that's in a famous movie from 1970, which many of you may not have seen, but it's a classic. It has Jack Nicholson in it when he was much younger, and it's called 5 Easy Pieces. Has anyone seen that? All the cockers have seen it, right? Great. So in this scene, Jack Nicholson plays the son of a fairly wealthy guy. And when Nicholson was younger, he was something of a child prodigy on piano. And I say something because his father thought he was better than he was and that he should go on and have a career as a concert pianist. Nicholson didn't want to do that because this is a movie from 1970. It's all about youthful rebellion. So instead of becoming a concert pianist, he goes down south to Louisiana and works on an oil rig and has a sort of trashy girlfriend, according to the father, who happens to be Karen Black. So he's down there and he's living this life as an oil rigger, when in truth, he's the son of a wealthy, Northeast, intellectual guy. He learns that his father is sick. So he's going home to see his father before his father dies, right? And, part of the movie is the road trip home and what he's, sort of thinking about himself. And so he picks up these two hitchhikers, which you did in the 60s and 70s. And they go to this diner to get something to eat. And so Nicholson sits down at the diner, and the waitress comes over, and she doesn't like his kind, right? Which is also a very 70s thing, you know, the reaction of the establishment not liking their kind. And so the waitress reflects this in the sort of bad attitude that she has to him. She comes up to him, and she asks him what he wants, right? So he says he wants a plain omelet, he wants tomatoes instead of potatoes, he wants coffee and some toast. That's what he wants. And she barks out, no substitutions. Nicholson says, what, you don't have tomatoes? And she says, only what's on the menu, right? And so Nicholson starts to say something, and she walks away, and she says, well, I'll come back when you've made your mind up. And he says, wait, I have made my mind up. I know what I want. And he says, I'll have a plain omelet, a cup of coffee, and a side order of wheat toast. And she says, I'm sorry, we don't have any side orders with that. And no, he's incredulous again. He says, what? You don't have bread? You don't have some kind of a toaster? You don't sell sandwiches with toast on it? And she says, well, I don't make the rules here. You want to talk to the manager? And he says, okay, I'll make it easy for you. Right? He says, I'll have an omelet, I'll have a chicken salad sandwich on wheat toast. Right? Hold the mayonnaise, no lettuce, no butter. Right? And then she repeats this. Right? Then this is her mistake, of course. She asks, anything else? And Nicholson, who has fantastic comic timing, right, says, a cup of coffee. And he pauses. And he says, and yeah, hold the chicken. Right? And she says, hold the chicken? And then he says, yeah, hold the chicken between your knees. And then she gets insulted, who knows why. And she points to the sign and says, basically, you know, we don't like your kind, so leave. And he gets up and he takes his arm and knocks all the water all over the place. And then they go out, and one of the hitchhikers says to him, wow, that was so clever. It was amazing the way you figured out the way you get your toast. And he says, yeah, except I didn't get my toast, right? So that's sort of the way it's been with copyright and consumers for some period of time. Right? We know what we want. For example, in music, we want individual songs, right? We don't want to buy the chicken salad sandwich of the entire album and pay all that much for it. Although, to his credit, Nicholson was willing to do that, right? Just to get the damn toast, which he never got. We didn't want to do that. You know, we want the individual songs. And that was sort of denied us, right? Until, you know, finally iTunes came along and figured out a way to do that. And there are other sort of examples of this too. For example, in newspapers, you know, there's a lot in the news about newspapers, including newspapers in Google as well. And, you know, some newspaper people are upset at the way things are. And what they're upset about is that people aren't buying as much hard copy newspapers. Now, I love hard copy newspapers. I read 4 of them a day. The New York Post, just because of the smut. Yeah, it's harmless smut, as smut goes, right? Though they did have some great stories about the Standard Hotel, which is very close to where Google is. Wall Street Journal, the New York Times, and my local Stanford paper. So I like it. It's a different experience, right? But I also get a lot of news online. And when you do that, there's sort of 2 ways to do it. You could go to, say, NewYorkPost.com, although I think the website is terrible. So I don't ever do that. I'd rather buy the thing. Or you could be searching for articles. You could go to, like, Google News or Yahoo News, which I don't do. I go to Google News for obvious reasons. You know? And you sort of see what the stories are. And then if there's one you're interested in, you click on it. And then you go to that site. Right? Now, when you do that, you know, you're actually consuming news, I think, as individual articles. And then the next question for the newspaper is to figure out how to keep you there. Right? You didn't get there by going on NewYorkPost.com. You get there by going on, say, Google or Yahoo News, and then it takes you there. And then you, as the consumer, have to figure out whether you're going to stay there, whether you're going to look at other articles, whether you're going to go to some other place. Right? And that's a different experience and a different challenge for it. One of the things that digital technology has done is what Marissa Meyer, who's our senior VP for search, calls the atomic unit of consumption. right? What is the unit by which you generally consume things? It used to be what copyright owners dictated it was, right? An entire album for physical reasons, or a DVD, right? Or a VCR tape. Whatever it was, you got to buy what they sold you, and that was it. You either bought it or you didn't buy it, right? With digital technology, it's different. You know, the way in which we consume things is much shorter now. So when I was doing the 5 easy pieces things, actually this was on Friday. I was going up to Harvard to give a talk there. And I went on Amtrak, a mistake, because right outside of Kingston, Rhode Island, the train broke down for 2 hours. And I made my talk like 5 minutes late. People were usually late, so it was actually on time. But I had left myself 2.5 hours. So I was sitting there for like 2 hours in the marshes in Kingston, Rhode Island, figuring out what to do. And I was bored, not surprisingly bored. So I had my BlackBerry with me, which has a browser, and I was trying to figure out what to do. And so I all of a sudden thought of 5 easy pieces. And so I did a web search, and up came that 1 minute and 52 seconds of that scene from the restaurant, right? Didn't give me the whole thing. In fact, I didn't even want the whole thing. I only wanted those 1 minute and 52 seconds, and since I had plenty of time, I was actually able to transcribe the whole thing, right? And in the form pretty much in which I gave it to you. Now, I did end up going out and buying the DVD for $9.53 afterwards. But the point is that I could actually find exactly what I wanted. And that's more the typical way, I think, in which we consume things now. And copyright industries have a choice. You either go with it or you don't. Right? You're not going to be, the saying in Silicon Valley is don't fight the internet. First of all, it's not a place, so you can't really fight it that way. Even though people talk about it as being war, you can't fight against something that doesn't have a place. Sort of like the war on terrorism. If terrorism is a tactic, how are you going to fight a tactic? So that's true for the internet. But it's here to stay, at least for quite a long time. So it doesn't make any sense to do that. What you should do, of course, is figure out, as I said, what people want, and then give them what they want. It's the only way to make money, frankly. And the sin of copyright, and I think it's been a large and rather growing sin, is that it's provided the means by which some copyright owners can avoid doing that. And it's not helpful. It's not healthy for them to do that. It's much better to adapt. Now, that's a hard thing to do, of course, is to adapt. Nobody wants to overthrow an existing business model and go to something else. It's unfamiliar, and you might not make as much money. But, you know, that's just the way it is. So Dylan Thomas, of course, had his famous poem in which he said, you know, rage, rage against the dying of the light. But, you know, he died. And, you know, we all will. And businesses will die, too, if they don't actually adapt. And I'll give you an example of the sort of tension in doing this. So today, in Vanity Fair, Michael Wolff, who wrote, you know, such a cloying, annoying, terrible book about Rupert Murdoch, has a article on him, and it's called Rupert to Internet. It's war. Right? And it's a whole discussion about Rupert Murdoch's sort of theory of how he operates his business models and things like that. And one of the things that he says here is Murdoch's approach to business. And I'll just quote it because it's really pretty good. Murdoch is not a modern marketer. He runs his business not on the basis of giving the consumer what he or she wants, but through the old-fashioned way of structural market domination. His world and training ground is the world of newspaper war, a zero-sum game where you wrestle market share from the other guy. You know, that's sort of a common way to do it, but I don't think he's actually going to be able to succeed in this. If by succeed, for example, he means making people pay online for the New York Post or pay for general news. You could maybe, and he has been, or the Wall Street Journal has been successful, at least in getting people to pay for that. That's a niche market. First of all, many people get their companies to pay for it. So, there's that part of it. But sort of general specialized news, people will pay for because it has value to them. But General news, which you can get from other sources, and lots of other sources, that's going to be a very hard sell. Because if you have a paywall for that, there's too many other places to go, right? And there are too many other media that aren't in fact established media. So when the U.S. Airways flight went down the Hudson, we actually saw it drift by our office. Our office is at 15th Street and 8th Avenue, although it goes all the way over to 9th Avenue. My office is on the 15th floor, and it's catty corner on the Hudson side. So when it went down, it wasn't the established news who gave, the first news that it happened. It was other people. So there was a guy on the ferry that was the first ferry to come, right? And he had an iPhone, which of course has a pretty amazing camera in it, right? And he took some of the real iconic photographs of that plane. The one where you saw all the people lined up on the wing. I actually have a friend whose sister was on that plane, and she was one of the ones who was sitting down because she had gotten off and the weather was too cold, and she tried to get her way back and people pulled her back up. But those were amazing photographs of it. And the story was broken by them. And then posted on Twitter, and then posted on blogs and other news sources. That's actually the way a lot of stuff happens this day. And you have to adapt to that. So, I would say that I certainly want copyright owners to succeed. We should. I do my bit for it. I have 8-year-old twins. I buy them every DVD for a kids thing that comes along. They've seen Ice Age 3 times in the theater. I happen to know the DVD comes out October 27th for it. They have Nintendo DS games, which are, some of them are like $35 for them, right? And since they're twins, I have to get 2 of them. Right? They have all these chapter book series, like the A to Z mysteries. That's 26 right there, right? A to Z is 26, plus the specials. There's the Geronimo Stilton stories. So, I buy a lot. I'm happy to give copyright owners my money. I'll give them more. But it's got to be for things that we want. It can't be for trying to thwart the things we want. And that's where I think there's been this disconnect with copyright. And to me, the best result in the future would be where we don't talk about copyright in a consumer way. Why? Because it's not being used to deny us what we want. The worst thing is for copyright owners to have the general public talking about copyright, because they're going to talk about it in a negative way, right? Things that don't work. So even President Obama found that out. Right, so some of you may remember there was something of a kerfuffle about the gifts that he gave to Gordon Brown. Right, Gordon Brown gave him some really cool, like wasn't a pen or something from a ship, something like that. It was the original wood. It was a really thoughtful gift. And what did Obama give to Gordon Brown? Well, he gave him a box set of American classic movies. I sort of winced at that. But the great part of the story, the reason I'm telling it, was when Gordon Brown allegedly went home to try and watch some of these, he couldn't. Right? He couldn't because there was regional coding on it. Right? So I've had the reverse. I've gone to London to try and get stuff for my kids, like Wallace and Gromit, Shaun the Sheep, that sort of stuff, which are British productions. Right? They're great. And I can't buy them because they're regionally coded for the UK. Right? I find that frustrating. This is not, trying to get stuff that's unauthorized. This is trying to buy the stuff in the store, and it doesn't do you any good to do it. Why? Because it's an old model of dividing up markets by regions. Now, that just isn't effective. It doesn't work, and it's not a great idea. And so Obama's first lesson on copyright, maybe his last one, I don't know, was giving someone generally a crappy gift that he couldn't even play on his own DVD player. Sort of serves him right, maybe. All right, so that's all the shtick I have. And I'm happy to spend the rest of the time answering questions on anything you want. So, fifth row. Yes, ma'am.
A lot of people are also saying that the content owners in the copyright industry missed the boat in terms of initially figuring out a way to monetize individual song downloads and such.
Right. Maybe even missed the dock.
Yeah, maybe just didn't even hit the water. So do you think that now that maybe some people are starting to understand what kinds of consumption people want, there are still barriers to monetizing that? For example, Spiral Frog went out of business. Pandora is about to go under at every other second. If people, if YouTube started charging money, it might not go over so well. So what do you think are other barriers to monetizing what consumers do want?
Right. So it would depend, of course, upon what the particular product is. And I think there are differences there. People tend to consume movies more as a whole, I think, even though I was looking, of course, at a specific scene, but I was looking at it for a specific purpose, right? If I wanted to actually see the movie, I would do what I did, which is to pay $9.53 with my Borders discount card and get the whole movie, right? Which is fine. In terms of music, thanks to Steve Jobs, I think we're, closer to that. But it's not only, of course, copyright owners that have this sort of desire to be proprietary and keep people there. iTunes Store is an example of that too. So when I got a video iPod, it was 3 years ago, something like that. My wife gave me one, and I thought it was great. And because I travel a lot, I thought I'd upload some of my DVDs and watch things, like the Wallace and Gromit ones I could get here. So I uploaded a whole bunch of my CDs, and then I tried to upload a DVD. And I couldn't because the motion picture industry didn't want DVDs to be uploaded. So I have a video iPod, but no videos on there, right? Now, what also happened is that my wonderful MacBook Pro, which I got free from work, had a hard disk failure, which is a bit unusual. But then I discovered I was really screwed on the music side. Why? Because while I got a new MacBook Pro, I couldn't sync my iPod to the new hard drive, right? Because they didn't want backwards sort of thing. I think that may have changed, but at the time that I did it, which was probably 2 years ago, it wasn't the case. And so you can't legally at least port your stuff. The Amazon Kindle is another example of that, right? You buy all that stuff, you buy 1984, and it gets wiped out because they got the wrong one. They sort of took care of that, but that's a proprietary thing too. So one of, I think, the big divides in marketing stuff is, are you going to be proprietary or are you going to be open, right? And so the struggle, I think, goes beyond, or the differences go beyond just copyright owners and users, which is sort of a false one, because clearly there are so many people who are creators now who work. People who have blogs, people who do lots of stuff. There are far many publishers than there were in the past. So the divide is probably at the consumer level between open and closed. And that's what, of course, Rupert Murdoch is complaining about. He wants paywalls, he wants things to be closed, and other people don't. So I think while there are specific hurdles there, there's a larger hurdle between how you want to sell your stuff or not. My own belief is that the focus on controlling people isn't a great business model. I mean, personally, I don't like to be controlled. Maybe I'll try to do the right thing, and if I don't, then I can be criticized, and I'll try and do whatever that is that's right. But trying to control the consumer experience all the way down is in some people's DNA. And that's what the article about Murdoch is, right? And Michael Wolff says it's not even that he's worried about getting paid. It's that he loves newspapers, which is a great thing. And he wants people to read hard copy newspapers. And I understand that. I love reading hard copy newspapers too. I would rather read a hard copy than I would online, although do a great mix of both, right? But I should have the choice what to do. I shouldn't be told that I can only do it on a hard copy. But there's a tremendous resistance to people doing that, because they think if you give that control up, then you're going to not make any money anymore, right? It's intuitively something that they believe in, and there's some basis for it. In the end, I think you have to sort of let it go and trust that you will. Whether that means you're going to have to make money by adding value to things that you used to be able to sell but can't, is an ever-evolving thing. I don't know if that answers your question or not. Yes, ma'am.
Well, the movie industry has done a lot of product placement within the movies.
Yeah.
Do you see some sort of parallel between that and something that the music industry can do as well?
So one of the things so one of the answers would be it depends on who the music industry is, right? There's sometimes when we say the music industry, we only think of the record labels, right? Or we think of performers in their relationship to the record labels and selling records, right? But most artists make their money on tours, right, and selling tchotchkes and other stuff like that. And so some artists, of course, have even signed with tour groups like Live Nation, right? Madonna did that, and a bunch of other people have done that. The record industry itself has moved to some of them to what they call 360 deals, right, which is where you as a recording artist sign with a label, but they get a cut of your tour receipts and your tour merchandising and things like that. So the industry has begun to at least move away from the sort of divided up world where there's the record that are sold, and then there's the tour that's different, and the merchandising is different. And I think that's sort of how they're doing things. And also, of course, when performing artists sell things, they will sell like special backstage, access and special photos or other things. So I sort of see it moving quite that way. I don't think they have an exact analog to product placement, unless you're going to sing a song about, GM trucks in there, or get a line about GM trucks in there. I mean, a lot of performing artists, of course, will have music videos in which certain things are featured, like Cadillacs and stuff like that. But it's not quite the same, I think. It's true. I mean, yes.
I think it illustrates how the challenges and the solutions presented by new technologies affect different kinds of media differently.
Right.
So with music, I've been saying that I think we need to have a renewed focus on tangible things. So the actual music, since it's so ephemeral, it can go anywhere, we haven't been able to bottle that. But concerts,
right.
merchandise themselves,
Right.
I think we need to regress towards a physical thing. Newspapers are the exact opposite problem. No one's interested in the physical market anymore.
Right.
And it's going electronic.
Right.
Movies could have a renewed focus on the tangible with movie theaters. So just I think the general point is a one-size-fits-all solution isn't.
Right. Yeah, I think that's true. So to take movies, if you look at other countries like Japan, South Korea, which have far greater, broadband penetration and far greater speeds than we do, one of the things that some of the motion picture companies have had to do is to change the way that their marketing works, right? So there used to be a very clear thing in terms of staggering releases, theatrical, then cable, then DVD, and airplanes, things like that. But in those countries which are fortunate enough to have real broadband, so, when I was trying to look at 5 easy pieces, fortunately we were stopped in a place where I had a signal. But, when the train started going, the ability to get a signal was not easy. It would break out a lot. Going home on Metro North, to Stanford along the New Haven line, you'd never have a conference call on that for any length of time because you couldn't get a signal the whole time. So in those countries where they have real broadband and real signals, you can watch high-quality movies on your cell phone, and people do. People write novels on their cell phones. We can't do that. So what's happened is that in those countries like South Korea, Time Warner has now released online their movies at the same time they do DVDs. They've sort of been forced into it, and as a result, there's a hope that will cut down on the amount of piracy. But I agree that each one is a separate thing and has to be dealt with separately. Newspapers also have some different things. So, for example, they have union contracts, which don't really exist in the music area, right? They have very, very high fixed costs in terms of presses and rent and stuff like that. They also had a lot of consolidation, and they took on a lot of debt in the past too. So those sort of very, very hard costs are difficult to shed in a short period of time. And other industries don't have quite that problem. Yes?
Hi, yeah. In today's talk, we've focused a lot on copyright's repercussions in the consumer space. I was wondering if you have any thoughts on its future uses in the creative space in regards to derivative works, transformative works, and how you see that taking shape over the next 5 years.
Right. So the effect of copyright on other people wanting to use portions of copyright works, sometimes the whole work, has played out in fair use, has played out in sampling, parody, things like that. So you had the early sample cases. There was one involving Biz Markie, who took a terrible Gilbert O'Sullivan song. Maybe that's redundant. But Home Alone Again was the name of that song, and he did, he sampled it, he did a bit more, and the district judge, who was Judge Kevin Duffy, who's here in the Southern District of New York, started off by saying "Thou shalt not steal," and he had obviously a very negative moral view of that. That led to a lot of licensing of samples, which may or may not have been a good thing. I actually think that Biz Markie probably took too much. I'm not sure that was really a transformative use of the song, rather than just taking the song and using it, in a different genre. So at least for me, that was an open question in that particular case. But it led to a lot of licensing of samples. And then you had a sample troll who came along based upon that, and that was Bridgeport. So Bridgeport Music, which bought catalogs, had and still has a business model of suing people, right? And suing people for tiny fractions of things. They filed, I think it was over 800 lawsuits in the Middle District of Tennessee. And a lot of those went up to the Sixth Circuit. And in one of those cases that went up to the Sixth Circuit, the defendant was Dimension Music. Right? The Sixth Circuit amazingly said that there's no de minimis requirement for copying of sound recordings, which turned on its head 300 years or a little bit less of copyright litigation. So that led to really changes in the way in which music was created, and in a fairly negative way. And that sort of continues today. So if you took the Danger Mouse Gray album, right, with the white album and the black, that's another example of an amazingly creative product that was shut down, by EMI. So I don't think there's been a great deal of progress in loosening copyright law up for derivative works. Hopefully, some labels have just sort of decided not to go after it because there's too many. Like I mentioned, I grew up in Northern California in the 1960s, and nobody I knew ever went to Vietnam, right? Even those who didn't have a draft deferment, because there are just simply so many people who just didn't go. They got their draft notice and they didn't go, and there were just too many people to go after. So online video presents an example of where it's very hard to go after everybody. And so some of the studios have taken, a more, I would say, enlightened approach, although that's a biased statement, of not going after remixes, only going after more straight up copying. So I think there's an example where the sheer volume of stuff that's out there makes it impossible to do what was easy to do, in the Biz Markie case. In that case, by the way, the record industry asked for and got a recall, which is a little bit usual. So what that meant is that they won, they got an injunction, and not just an injunction, but all the record stores that hadn't sold that album had to then give it back to the record label, right, which destroyed them. I fortunately had a friend who had a record store, and he saved the copy for me, so I still have one. That's, you can't do anymore. Recalls just simply aren't going to work. Yes.
So I apologize ahead of time as a prelude for my lack of intellectual property based knowledge. But my question is, I was recently reading about Google Books actually and all the lawsuits
Yeah.
arising. This is a little bit of a topic.
Right.
And it just seems to me like you were saying that they should kind of open up the market and make it less based on kind of propriety-based kind of access and make it easier for the consumer to access what they want. But in the idea behind Google Books is to provide access. It seems like it's just shifting who makes a profit off of those books. Right now, Google is making a profit off of the advertising associated with individuals clicking on Google Books. It just seems like you're shifting from publishers and producers of proprietary-based books or whatever else. Just shifting into like a third party like Google for Google Books. Is that a true assessment? Would you
Right.
agree with that statement? I don't know.
Right. So, even though I work for Google, I don't speak for them.
Right, I understand.
Right. So, but I'll tell you some of the technical aspects of it, and then you can reach your own conclusion. Right. So, the Google Book Search initiative had two components to it. One of them was one where we work with publishers and authors. That actually came first, right? So publishers gave us books, we then scanned them, and when you're doing a search for something, you can always do a siloed search, right? Now we have universal search, which means that if you type into our search box something, whatever it is you're looking for, it used to be you only got text. And if you wanted video, you had to go to the video silo. If you wanted images, you went to that. If you wanted books, you went to that, right? For the last 2 years or so, I think, we've had what we call universal search, which may be the first thing that comes up is a video. Maybe you didn't even know there was a video, right? But that would be the first thing that comes up. You can still do siloed searches for book search. So when that started, it was siloed. So we scanned it. And then if someone was looking for something, that would be a search result that came up, and you would see a certain amount of it, whatever the amount was that the publisher authorized us to do. Those were in-print books, right? Those were books that were more current, maybe a little bit older, but still in print. Okay, now, the vast majority of books are out of print, right? And so what do you do for out-of-print books that nobody has an interest in at all, right? Because they don't know they exist. So in the introduction, it was mentioned that I had done this 6,000-page, 8-volume treatise on copyright. And when I was doing that, it took more than a year to do, and it took like 7 years to do. And if you consider all the work I'd done before, it probably took like 14 years to do. When I first started out as a lawyer, you had Westlaw or Lexis, maybe. You had those. And they were actually dedicated terminals, right? Westlaw came, and they installed the terminal, and you bought the service, and it was a metered service, right? Now, for universities and things, they would buy a general subscription. But generally, the way law students did research was to go in the library. And you were limited to what was in your own library. Now, maybe there were books that were in other libraries, and you would get interlibrary loan for those, but even there, more often than not, you had to schlep to that library, because maybe that library didn't want that book out of their stacks, right? So what you could get access to was limited to the physical stuff that was in your own library, or maybe a little bit beyond that. And, your universe for what you had was that. And those were almost entirely law books, right? There weren't a lot of law libraries that had non-legal books in them. They didn't have books about statistics. They didn't have books about economics. They didn't have books about sociology. That was undergraduate stuff, right? But how would you know if a sociologist, a historian, a psychologist, a linguist, a statistician, a mathematician had said something of interest about copyright? Because it's in fact true that non-lawyers have a lot of interesting things to say about law. And historians at least are much better researchers than most lawyers are. Right? So it wouldn't be surprising that historians would have a lot of interesting things to say about, legal issues. But you'd never know it. And so how are you going to know it? You have to search. Well, where do you search? If it's in a physical library, you're still out of luck. Even if you go to a university library, a great university library, unless that book is only about copyright, which is unlikely, you're still not going to know there's anything in that book that has stuff that's relevant to you. The only way to do it is to make it available to people to search online, right? And so what happened with out-of-print books was the belief that Google's mission is to organize the world's information and make it, accessible and useful, and that's a good thing. But what happens when most of the world's information is not available to you, right? The web isn't the whole world by far. In print is not the whole world by far, right? There's a massive amount of really interesting stuff in out-of-print books. So that was the reason behind it. And because it's so incredibly massive, you couldn't do deals like that on an individual basis for many reasons. The publishers aren't around. The authors may have got a reversion of it, and you don't know where they are, right? It was impossible to do. So you had a choice. Either don't do it, because it's too hard to do those one-on-one things, or do it. And do it in a way that you think still respects copyright law, right? So we scanned as many books as we physically could at a time, and we're continuing to do that. But what we showed were only snippets, right? 1 sentence, 2 sentences, 2.5 sentences, whatever it is. Stuff that anybody, even the most copyright maximalists who exist, and there are a lot of them in New York City, would think is fair use if done in the hard copy world, right? Not a lot different than bibliographic stuff, not a lot different than what you would do in a paper and that you would think would be fair use, right? And that way you get to learn about stuff. Now, when I wrote that book, I did that. I went to Google Book Search, and I found an amazing number of books by historians, sociologists, economists, and people like that taught me stuff I wouldn't have learned. And I bought those books because it didn't do me any good to get the little snippet, because that wasn't enough, It maybe gave me enough to know whether I wanted to buy the book, and then I went and tried to buy it. Right? So I bought hundreds of books that I never knew existed solely because of that. And so what we were sued for was the back-end copying of it, right? It's true. You had to scan the whole thing so you could show that snippet. But it wasn't like we wanted to scan. It wasn't like that was a good in and of itself. It wasn't. It was an incredible difficulty and an expensive one, right? So the question would be, are you going to allow back-end stuff that is at the consumer level fair use, right? And that was what the case was about. Now it's changed, of course, because what happened is that after we were sued by publishers and as a class action by authors, the authors came to us. This is one of the technical things most people don't know. The authors came to us and said, look, there are a ton of out-of-print books there that we would like your help in selling. Why? Because you can't get them in the bookstore. Right? There's no way. They're sold. I mean, most of the stuff that's in Barnes & Noble and Borders is pretty recent stuff. Right? So you don't need Book Search to go walk over to Barnes & Noble at Union Square and get a lot of that stuff. You do need a search for stuff that you don't know exists, or that you don't know who the publisher is. So they came to us and said, can we figure out a way to sell this back catalog stuff? And I'll give you an example. I have a book on fair use, or I had a book on fair use that was published by B&A in DC. Went through 2 editions, and I had a clause in my contract that said that the rights reverted to me when it went out of print. Right? So I would be one of these people. Someone wanted to buy that book. I would think that's great. But I didn't know it was out of print. The way I found out it was out of print is that somebody at HBO wanted a copy of it, and I called up the publisher, and they said, oh, we destroyed all the copies. I said, why did you do that? And they said, well, it's out of print. I said, well, I didn't know that. Right? So I had the rights to the book, but nobody, nobody could get it. I would have authorized anybody to reproduce it and sell it. I had another book that published by them that I got the rights back for. They then turned around and gave it to Google to scan, never asked me, even though I had the rights. I didn't complain to them. I thanked them. Great, because if anyone buys the book, I'll make money, right? So that is a different way of looking at it, I think. Now, what some copyright owners will say is, well, the default is you have to ask our permission before you do anything. And I would say, well, we do have fair use. We could disagree about whether it is fair use or not to make an entire copy of something so that you can see a snippet or two. And that's what the original case was about. So November 9th is the date that we and the publishers and authors have to give to Judge Chin a revised settlement agreement of some sort. And we'll see what happens. It's certainly getting a lot of press. Yes?
You talk about publishers publishing to users and consumers, but I'd like to talk about copyright going the other way, that users and consumers in the Web 2.0 world, publishing stuff.
Right.
And a good example is when you read the smut in the New York Post,
Yep.
because he bought MySpace, and the end user thing is, so when Spitzer's girlfriend's pictures are in the New York Post, it's because she's signed away the rights to them on MySpace.
Right.
And when Facebook started, they had to change their rules.
Right.
But even more so is how much is the expression of users, even in the form of social graphs, their property and copyrightable, so that even in, say, my searching on Google I would have control over that if you were to transfer that information to other people.
Mm-hmm. So I made some reference to that earlier, which is I believe that the sort of lines between publishers and users, the copyright owners and users, is difficult to maintain in a number of those cases, right? Because there are a lot of people who are publishers. Bloggers, are publishers. And a lot of the established media does very well with that. So I've had two blogs. I had sort of a general copyright blog. And when I had that, I had people from the LA Times, New York Times, Wall Street Journals, and other calling me up and asking me about stuff. And they would then write about it too, right? And I think that was great. I never complained. I didn't care if somebody copied what I did. And I think it is far more of what you're talking about, which is that it flows both directions. And I think that's great. And I think we all benefit if it flows both directions. The idea that they're going to be gatekeepers and that the gatekeepers are going to determine what we see or what we hear or what we learn is something, hopefully, that we're moving away from, whether they like it or not.
But I saw the guy from Pandora, at a similar thing, and they said to him that, when they make that model of what your taste is, shouldn't you be able to have that and can take it to, say, another service? Because really that is your expression, and as such, belongs to you.
Right. So Google has internally a group of people called the Data Liberation Front. Whether that's a good name or not, there's some debate about that. But the idea is precisely that. Now, all the data that you have should be portable. It shouldn't be tied. You can leave when you want to. Right? So in the older days of spreadsheets with Lotus 1, 2, 3, of course, you spent a lot of time inputting data. And it was on a proprietary format. And it made it very difficult for you to port to a different spreadsheet, so that there was economically, you were forced to stay with the one particular one you have. And as I mentioned in response to your question, that's really the divide. The divide is between controlled and proprietary things and open things. And you can appreciate why people want to have proprietary ones, because they want you to stay there. But sort of like relationships, personal relationships, right? The best way to make people stay is to give them a reason to stay. Not, you have to stay with me. It just doesn't work. Yes?
It seems like as the internet becomes more widespread use amongst teenagers, especially grows, the attitude towards them dealing with downloading is becoming sort of less of a moral problem for those people. How do you see that sort of coming into play in the future of sort of copyright and fair use? And do you think that it should make a difference?
So I'm not quite sure how to give you a specific answer to that. So I would say I have 8-year-old twins, and my daughter. Actually, we have 2 computers side by side. Right, I have 2 of everything, and so she was having trouble getting on, and I. For whatever reason. And I started to click onto Firefox, and she says, "No, Daddy, I use Internet Explorer." I thought, do you know who makes Internet Explorer? But she hasn't gotten to the point about downloading things yet. And I don't know what it'll be like when she gets to that point. But certainly I think as parents, you have a moral obligation to teach your kids things, which I do by buying everything on hard copy, or by, if it's a reading program or something, like I bought one for my son, we pay for it. So I, at least on the moral level, you have to teach by doing. You can't tell them to be moral, but then not be moral yourself. You have to actually be moral, at least when you're with them. So I do. I don't have any downloaded anything on my own systems. But I have a feeling your question was more broad about where I see sort of distribution of things going, right? So, in the days of, say, tapes, musical tapes, there was some copying, but most people didn't do it because the tapes were so cheap. Why would you bother with that when you can get a much better quality, decent audio tape? And so what I would like to see happen is that people, being content owners, make stuff available in forms that people want and at a price that makes sense for everybody. And once that happens, there will be people who will always want things for free and who will copy things, and that's always been the case. But I don't believe it's true for the vast majority of people. If you can make it simple and easy and cheap and give people what you want, then that's what I think we'll do. And that's where I would like things to go. Yes?
I have a question. What do you think about when people, team up to find, loopholes in copyright? Because I know, for example, during Fashion Week, if you videotape a show, you are only allowed to play 45 seconds of it on your blog or your website. They have a limit. So what people were doing is different websites were teaming up, and somebody would have the first 45 seconds. If you'd like to see the rest of the show,
right
here. And
right, gotcha.
So you could actually watch the whole show through clicking, say, 5 different websites.
Right.
So what are your thoughts on?
Right. So I think it was Judge Learned Hand who said you have no obligation to pay more taxes than the government asked you to pay. Right? So I'm not sure that if we're talking about loopholes necessarily. I mean, if it's legal to do, then it's legal to do, and I wouldn't call it a loophole. But I don't think there's any copyright in that at all. First of all, it's not fixed, right? It's a live event, like taping a marathon, right? That's just a live event. Now, it might have been a contractual violation. So, if you as a videographer got access to Fashion Show and you had to sign something saying, I will not put up on my blog more than 45 seconds, and you gave it to somebody else who put up their 45 seconds, that's a contract issue. So YouTube, for example, has limits. I think it's 10 minutes on the amount that you can upload. And some people try to get around that, as you know, by doing part 1, part 2, part 3, that sort of thing. That I don't think it does it if it's the same person, right? So, but your example, I think, involves a non-copyrighted work, which would be a contractual violation, not a copyright violation.
What are your thoughts on letting consumers choose what they pay and how much they pay for digital content?
Right.
Kind of like Radiohead experiment.
Yeah, right. That was a great experiment. So I think that should be up to bands or copyright owners to decide. I don't think that should be a general rule, because I do think that copyright owners should be able to decide what their pricing is and whether they're going to distribute it or not. And if they make mistakes, then they made a mistake. That's their thing. I don't think the default rule should be we get to decide how much your you sell your work for. I think it was an interesting experiment. I think it showed that people will actually pay for things that they don't have to pay, and maybe will pay more for.
I think Radiohead made the most money on the album.
Yeah, it was great. Now there are other albums, by older groups where they made more money because the labels didn't give them any money, too. So, as a matter of course, you're going to make more money. But I think that was a really cool experiment. But I don't think it should be a legal requirement for people to do. Yes.
I'm not sure if you're aware. You probably are. The Swedish piracy party. Or
Yeah.
Pirate party, rather.
Right.
I was wondering if you thought it's just basically a political party in Sweden, I guess, to overturn current copyright law and to. I'm not 100% sure all their nuances and their stances, but I was wondering if you thought it was counterproductive or if you think they have a valid, argument.
Yeah, I really don't have any views on it. I'd leave that up to the Swedes to figure out for themselves. Yeah.
Copyright term, do you think it's too long?
Yep.
Given incentive?
I'd go back to the 1909 Act if we could. Formalities, 28 years plus 28 years. That was more than enough for most people. If you look at the renewal rates under the 1909 Act, the renewal rate was about 10% on average, right? Which means that for 90% of the works, 28 years was enough. That was it. Why can you say that? Because it only costs $10 to get another 28 years and a truly easy government form. So if 90% of the people didn't pay $10 for another 28 years, you could say for 90% of the people, 28 years was enough. Now, there were some, like motion pictures, that had a 74% renewal rate, which is pretty good. And that would indicate to you that they should have 56 years, probably because it made sense for them to do. One of the problems is that we've given the same term of protection to all works, and a super long period of protection at that. Looking at the renewal rates, I think, is a fair way to do it because it shows you what copyright owners themselves thought and how they acted in response to incentives. So in my dream world, which would probably be other people's nightmare world, I would go back to the 1909 Act because I think it was a much fairer way to actually do it. I think people should have the ability to make a lot of money. I want them to make money, and I give them my own money, right? But you shouldn't have a term of protection that far exceeds what you actually need, and that in the end leads to fewer works, as in your example, right? So if you have all of these works that you would use to make derivative works but can't because you know you're going to be sued, you won't do it. I mean, any company of any size is simply not going to take the risk to use works, even if you know that the company went bankrupt, and and it's unlikely that they're going to show up. You can't do it. Certainly, as a publicly traded company, it would be irresponsible to do it. Okay, I don't know. What's the rules, Sir Michael?
One or two more. Let's say two more comments.
Okay.
That'll be it.
Yes, ma'am.
With the rise of online accessibility and I guess more and more digitization efforts and more things that are available online, I was wondering if you think that we'll have to see some sort of international harmonization in terms of copyright policy because of the possibility of infringement in one country, whereas domestically it's not infringement.
Right. Sure. So we have a lot of that already, I would say. So we have those countries that are members of the Berne Convention, those countries that joined the GATT, which in 1994 was expanded to have intellectual property in the TRIPS section. We have the 1996 WIPO treaties, and now we have ACTA, the Anti-Counterfeiting and Trade Agreement, that's being negotiated among big countries, who are then going to try and sell it to smaller countries. So we have a lot of that. And certainly on the level of, is something infringement or not, we have all those things. Some people might wonder about remedies, do all countries have adequate remedies? I actually approach it the other way, which is I think we have too much harmonization. And for this reason. So let's say we all agreed domestically that life plus 70 was a bad idea because there was no author on the face of the earth who would have created a work only if it was life plus 70, not life plus 50, right? There's no author who ever said, life plus 50 years after my death isn't enough. I'm just not going to create. You gotta give me those extra 20 years or I'm not doing it. Right? That's not true. Right? And so what do we get for the 20 years? Well, we got 20 more years where you can't use something and didn't lead to any more works. So let's say that we decided we wanted to go back to life plus 50 because it was a mistake. Maybe even life plus 50 is a mistake. Maybe we go whole hog and go back to the 1909 Act. Whatever it is that we decide domestically, we want to change our law because we think for our purposes, this is what works best for the United States. We couldn't do it. We couldn't do it because we've obligated ourselves internationally not to do it. And we keep obligating ourselves. Now, the game that we play is that we think it's always going to be good for us. And what we want to do is to get other countries to increase the level of their protection. So we want them to obligate, like South Korea. They didn't want life plus 50, but we, leaned on them. Now they have life plus 70. As a result, they have to subsidize their own book industry because their book industry, right, relies on a lot of translations. There's a lot of domestic works, but they have translations. So as a result of South Korea going to life plus 70, the government had to subsidize their book industry. That's wrong. It's really wrong, I think, to make other countries do that when it's not going to increase the number of works for anybody. So harmonization at the level of stopping commercial piracy, I absolutely agree with. But we're going far beyond that. We're harmonizing anti-circumvention stuff that's in the DMCA. We're harmonizing term. We want to harmonize statutory damages if we can get away with it, right? We're way past that sort of counterfeiting stuff, and we're deep into the weeds of stuff where there are legitimate differences of policy about it. And I think it's wrong to make that an international obligation that you can only back out of by abrogating a treaty. That's not something countries want to do. So that's my answer to that.
One last question if someone wants to go really quickly.
Cool. All right. Thank you very much. It was wonderful to be back.